Here's a wild wedding eve scenario that turned into a landmark contract case. A bride is hours from I do. The groom, a successful doctor. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. He slides over a prenup on the eve of the wedding. No lawyer for her. Time is tight. Sign, or the wedding's off. She signs. Years later, the marriage ends. That piece of paper becomes the whole fight. That's Simeone v. Simeone, 1990, Pennsylvania Supreme Court. Let's run the timeline. Setup: engaged couple. He's clearly well off. On the eve, he presents a prenup capping her potential support. It's an ultimatum, not a negotiation. She signs without independent counsel. Breakup. She challenges the prenup. Her argument: it wasn't fair. Her argument: she had no lawyer. Her argument: the timing was coercive. Her argument: there wasn't detailed financial disclosure. Trial fight. Lower courts wrestle with two competing ideas: family law fairness, contract law. Now the pivot, the Pennsylvania Supreme Court steps in. The court says, treat premarital agreements like any other contract. Adults are bound by what they sign. Courts aren't there to rescue you from a bad deal just because it's lopsided. Key rule from Simeone: a prenup is enforceable absent fraud, misrepresentation, duress, no automatic fairness review. No redo because you didn't get a lawyer, though having one is a very good idea. Failure to read or fully grasp every provision is not a defense. If you sign, you own it. What about disclosure? The court emphasized you can't hide assets or lie. But the court rejected a rigid paternalistic requirement that judges second-guess substantive fairness. The standard is voluntariness and honesty, not whether the deal turned out good. So did last-minute timing automatically equal duress? Not in this case. The court said pressure before a wedding isn't the same as unlawful coercion. There was no evidence of fraud or misrepresentation. She generally knew he was a high-earning physician. Result? The prenup stood. Why it matters: cementing freedom of contract for prenups. Limiting judicial paternalism. Courts won't rescue parties from bad bargains. Focusing disputes on disclosure and voluntariness, not subjective fairness. Practical takeaway: get independent counsel early. Exchange clear, written financial info. Avoid last-minute presentations. Give time to review. Don't sign anything you wouldn't want read aloud in court. Simeone v. Simeone isn't a romance story. It's a contract story. In Pennsylvania, your signature on a prenup means what it says unless you can prove fraud, misrepresentation, actual duress. Always remember to read before you sign. Thank you for watching. If you enjoyed this case, please like, subscribe, and ring the bell for more. See you on the next one.